I watched from my kitchen window as the HOA construction crew started breaking ground on what was clearly my property. And I knew right then, I had these people exactly where I wanted them. My name is Richard Garrison, and I had been living in the Pinewood Springs development outside Asheville, North Carolina, for about 3 years when this whole mess started. I purchased a 5-acre property that backed up to a gorgeous stretch of woodland, which was exactly why I bought the place. The trees, the privacy, the wildlife, it was everything I wanted after spending 15 years in a cramped apartment in Charlotte working my way up through the tech industry. When I finally sold my startup, I had enough money to buy something nice and actually enjoy life for once. The Pinewood Springs Homeowners Association was one of those necessary evils that came with the territory. The neighborhood was upscale, well-maintained, and the HOA kept everything looking pristine. For the first 2 years, I barely interacted with them. I paid my dues, kept my lawn neat, and they left me alone. That was exactly the relationship I wanted. Then Patricia Hendricks became the HOA president. Patricia was 52 years old, divorced, and had apparently decided that micromanaging the entire neighborhood was going to be her full-time occupation. Within a month of taking over, I started getting notices about everything. My mailbox was the wrong shade of black. My garden gnome was not on the approved decorative items list. My oak tree needed trimming because one branch extended 3 inches over the acceptable canopy radius for properties bordering common areas. I complied with most of it, mainly because I did not want the hassle. But Patricia seemed to take my compliance as weakness rather than cooperation. The notices became more frequent, more petty, more invasive. She wanted to inspect my backyard to ensure my fire pit met regulations. She wanted to verify that my shed was the approved color. She sent me a certified letter demanding I remove a bird feeder because it was attracting too many birds, which apparently violated some obscure clause about wildlife management. The final straw came when she showed up at my door on a Saturday morning in March with a clipboard and a measuring tape. I was still in my bathrobe, drinking coffee, and not remotely prepared for what was about to happen. "Mr. Garrison, we need to discuss your property boundaries," she said, not bothering with pleasantries. I took a slow sip of my coffee. "Good morning to you too, Patricia." "What about my property boundaries?" "The HOA has been reviewing the original development plans, and we have discovered that a portion of what you believe to be your woodland is actually designated as common area green space." I set my coffee down carefully. "Excuse me." She held up a document that looked official, but that I had never seen before. "According to this survey from 2008, the woodland area behind your property line actually extends into HOA jurisdiction by approximately 40 feet. We will be developing that area." "That is not possible," I said, keeping my voice level. "I had a complete survey done when I purchased this property. I have the legal documents showing exactly where my property ends and where any common areas begin. That woodland is mine." Patricia gave me a tight smile that did not reach her eyes. "I think you will find that your survey is incorrect. The HOA has made its decision. We will be constructing a community storage facility on the disputed land." "The land is not disputed. It is mine." "We shall see about that, Mr. Garrison. Construction begins in 2 weeks. If you have any concerns, you can bring them up at the next HOA meeting." She turned and walked back to her white Lexus SUV, leaving me standing in my doorway with cold coffee and rising blood pressure. I immediately called my real estate attorney, Marcus Chen, who had handled my property purchase. He was not happy to hear about Patricia's visit. "That makes no sense," Marcus said after I explained the situation. We did a complete title search and boundary survey. That woodland is definitely part of your property. You still have all the paperwork. Every single page. I keep it in my safe. Good. Get it out and scan everything to me. I want to see what the HOA is claiming they have. I spent the rest of that weekend going through my property documents. Everything was in order. My property deed clearly showed the boundaries. The survey map showed the woodland extending all the way back to a creek, which was the natural border of my land. There was no ambiguity, no gray area, no dispute. Marcus called me Monday morning. Richard, I have looked at everything you sent me, and I also did some digging into the HOA's claims. What Patricia showed you is complete fabrication. That 2008 survey she mentioned does not exist in any official capacity. The actual 2008 survey, which is on file with the county, shows your property lines exactly as we documented them. So she is just lying. Essentially, yes. But here is where it gets interesting. I did some checking, and the HOA has been talking about adding storage facilities for the past year. They put it to a vote last summer and it passed, but they do not have any land to build on. All the common areas are either designated green space that cannot be developed, or they are already being used for other purposes. So they decided to just take my land. That would be my guess. I am going to send them a cease and desist letter today. That should stop any construction. But it did not stop anything. 2 weeks later, exactly as Patricia promised, construction crews showed up at 7 in the morning on a Tuesday. I was eating breakfast when I heard the sound of heavy machinery. I walked out to my back deck and saw that they had already marked off an area of my woodland with orange stakes and caution tape. I grabbed my phone and called Marcus immediately. They are here. They are actually doing this. Do not confront them, Marcus said. I am serious, Richard. Do not engage with the workers or with Patricia. Let me handle this legally. But I was already walking across my lawn toward the construction site. I was not going to stand by and watch them destroy my property. 3 workers were unloading equipment from a large truck. A man in a hard hat who appeared to be the foreman was reviewing something on a tablet. Excuse me, I called out. You are on private property. You need to stop what you are doing and leave. The foreman looked up, confused. We have authorization from the Pinewood Springs HOA. This is designated common area. It is not. This is my land. I have the deed and survey to prove it. He looked uncomfortable. Look, man, I just do what I am told. I have a work order here from Patricia Hendricks authorizing this construction. If you have a problem, you need to take it up with her. I am taking it up with you. Get off my property. One of the other workers pulled out his phone. I am calling Patricia. 5 minutes later, Patricia arrived in her Lexus, moving faster than I thought physically possible. She emerged from the car with her phone already pressed to her ear, presumably with her lawyer or someone else she thought would intimidate me. Mr. Garrison, you are interfering with authorized HOA construction, she announced loudly, probably for the benefit of whoever was on the phone. Patricia, this is my property. You know it is my property. My attorney sent you a cease and desist letter. We reviewed your attorney's letter, and our legal counsel has determined that it lacks merit. The land is ours, and we are moving forward. I pulled out my phone and opened the photo app where I had stored images of all my property documents. Here is my deed. Here is my survey. Here is the county record showing the property boundaries. You are trespassing. She barely glanced at my phone. Our documentation shows otherwise. Now, I suggest you return to your home before this becomes a legal matter. It is already a legal matter. Then I suppose we will see you in court. She turned to the foreman. Continue with your work. You have full authorization from the HOA. I called Marcus again as I walked back toward my house. I was shaking with anger, but I forced myself to stay calm. They are refusing to leave. Patricia is telling them to keep working. Marcus was quiet for a moment. Okay, here is what we are going to do. I am going to file for an emergency injunction to stop the construction. That should happen within a few days. In the meantime, document everything. Take photos, videos, keep a log of when they are there and what they are doing. Do not physically interfere, but make sure you have a complete record. This is insane. I know. But trust me, we are going to win this. They do not have a legal leg to stand on. That afternoon, I set up several trail cameras around the construction site, the kind hunters use to monitor wildlife. I positioned them to capture every angle of the work area. I also started a detailed log in a notebook, writing down times, dates, and descriptions of all the activity. Over the next 3 days, I watched as the construction crew cleared trees, leveled ground, and poured a concrete foundation. Each falling tree felt like a personal attack. That woodland was one of the main reasons I bought the property. I had spent countless mornings walking through those trees with my coffee, watching deer and foxes, listening to birds. Now, it was being destroyed to make room for a storage shed that nobody needed. Marcus filed for the emergency injunction, but the court system moved slowly. We had a hearing scheduled for the following Monday. In the meantime, the construction continued. On Thursday, I got home from a meeting in Charlotte to find that they had framed out the entire structure. It was bigger than I expected, maybe 30 feet by 40 feet, with tall walls that would accommodate large storage units. They were working fast, probably because Patricia knew the injunction was coming and wanted to get as much done as possible before a judge could intervene. Friday morning, I woke up to the sound of roofing work. By that evening, the storage facility had a complete roof, walls, and a large rolling door on the front. It was essentially finished, at least structurally. They would still need to do interior work, electrical and finishing, but the main building was up. That was when I had my realization. That was when the plan came together. I called Marcus. Let me ask you something. If someone builds a structure on your property without permission, who owns that structure? The property owner would own it. Why? Because they just built me a very nice storage facility. Marcus was silent for a moment, then I heard him start to laugh. Oh, that is brilliant. Richard, that is absolutely brilliant. So if we win the injunction and prove the land is mine, everything they built belongs to me. Technically, yes. Though they would likely argue that they should be compensated for the materials and labor. Even though they knowingly built it on someone else's property after being told to stop. That would be up to a judge, but I like our chances. Trespass is trespass, and if they willfully ignored your ownership claims, that strengthens our case significantly. Then let them finish it. Let them do the electrical, the interior, all of it. The more they invest, the better. Marcus hesitated. Richard, I should advise you that this could be seen as entrapment or as you acting in bad faith. How? I told them to stop. You sent them a cease and desist. We filed for an injunction. I documented everything. They made the choice to keep building. I'm not trapping them into anything. They are trespassing, and I am simply allowing them to dig their hole deeper. Okay, but we document everything. Every warning, every attempt to stop them. We make sure that when this goes in front of a judge, it is crystal clear that you did everything possible to prevent this, and they ignored you. Agreed. That weekend, I watched as the construction crew returned to do the interior work. They installed electrical panels, lighting, climate control, and divided the interior into individual storage units with roll-up doors. They were doing quality work, I had to admit. This was not some cheap shed. This was a professional storage facility that probably cost the HOA somewhere in the range of $80,000 to $100,000. Patricia came by several times to inspect the progress. On Sunday afternoon, I was sitting on my back deck, drinking a beer and watching them work. She walked across the lawn toward me, that same tight smile on her face. "Enjoying the show, Mr. Garrison?" "Very much, actually. You all are doing a great job. I am glad you are finally seeing reason. Perhaps you will drop this frivolous legal action." "Oh no, I am going to see it through to the end. I am just appreciating the quality of the construction." Her smile faltered. "The judge is going to rule in our favor. We have documentation proving this is HOA land. Then you have nothing to worry about." She studied me for a long moment, and I could see her trying to figure out what game I was playing. But her arrogance would not let her consider that she might actually be wrong. She had convinced herself that her fabricated documents were real, or at least that she could intimidate me into backing down. "Good day, Mr. Garrison." She turned and walked back toward the construction site. The hearing for the emergency injunction was scheduled for Monday at 10 in the morning. I met Marcus at the courthouse in Asheville, carrying a folder full of documentation. Marcus had prepared everything, including the survey records, deed, county filings, and a complete timeline of events with photos and videos from my trail cameras. Patricia arrived with her attorney, a stern-looking man in his 60s named Donald Pritchard. I recognized him as one of the more aggressive real estate attorneys in the area. The HOA had clearly decided to invest serious money into this fight. We entered the courtroom of Judge Rebecca Morrison, who had a reputation for being no-nonsense and deeply unimpressed by HOA disputes. She had heard enough petty neighborhood arguments over the years that she had little patience for anything that wasted her time. "All right, let us get this moving," Judge Morrison said as she reviewed the case file. "Mr. Chen, you filed for an emergency injunction to stop construction on property you claim belongs to your client. Explain." Marcus stood. "Your Honor, this is a straightforward trespass case. My client, Richard Garrison, owns a 5-acre property in the Pinewood Springs development. The boundaries of his property are clearly established in the deed, the survey, and county records. Despite this, the Pinewood Springs HOA has constructed a storage facility on his land without permission. We provided them with documentation proving ownership, sent a cease and desist letter, and they ignored it all." Judge Morrison looked at Pritchard. "Mr. Pritchard, what is the HOA's position?" Pritchard stood, adjusting his tie. "Your Honor, the HOA has documentation showing that the land in question is designated Common Area Green Space. We have a 2008 survey that clearly establishes this." "May I see this survey?" Pritchard handed a document to the bailiff, who passed it to the judge. She studied it for a moment, then looked at Marcus. "Mr. Chen, your response." "Your Honor, that survey is not a legitimate county document. We pulled the actual 2008 survey from county records, and it shows something completely different." Marcus handed his own documents to the bailiff. "This is the official survey on file, which clearly shows Mr. Garrison's property boundaries extending to the creek, well beyond where the HOA built their facility." Judge Morrison compared the two documents, and I could see her expression change from neutral to annoyed. "Mr. Pritchard, where did your client obtain this survey?" Pritchard looked less confident now. "It was provided by the HOA president, Patricia Hendricks. She stated it was from the original development records." "This document has no county seal, no surveyor's stamp, and the formatting is inconsistent with standard survey documentation from that period." Judge Morrison set the papers down and fixed Pritchard with a hard stare. Did anyone from the HOA verify this document before proceeding with construction? We relied on the information provided by the HOA president, Your Honor. That was unwise. She turned to Marcus. Mr. Chen, do you have the county survey records? Yes, Your Honor. We have the original 2008 survey, the 2022 survey done at the time of purchase, and a certification from the county surveyor's office confirming the property boundaries. All three are consistent and clearly show the construction site is on Mr. Garrison's property. Judge Morrison spent several minutes reviewing all the documents, comparing surveys, checking deed descriptions, and verifying county seals. The courtroom was silent except for the rustling of papers. Finally, she looked up. I am granting the emergency injunction. All construction is to cease immediately. Furthermore, I am ordering the HOA to show cause within 30 days why they should not be held liable for damages, including the cost of removing the structure and restoring the land. Your Honor, Pritchard said, standing quickly. The HOA has invested significant resources into this construction. Surely there must be some consideration for that investment. Mr. Pritchard, your client built a structure on someone else's property after being explicitly told it was someone else's property. The fact that they invested money into this venture does not create a right to trespass. If anything, it demonstrates a willful disregard for property rights. Motion granted. Court adjourned. Outside the courtroom, Marcus was grinning. That went better than I hoped. Morrison was not happy with them. So what happens now? Now they have 30 days to respond to the show cause order. They will probably try to negotiate, offer to pay you something to keep the structure or to buy that portion of land. But you have all the power here. They trespassed, they built without permission, and a judge has confirmed that the land is yours. What if I want to file trespassing charges? Marcus considered this. You could. Criminal trespass would require proving they knowingly entered your property without permission. Given that you warned them, I sent the cease and desist, and they continued anyway. You probably have grounds, but that would escalate this significantly. Good. Let it escalate. I spent the next week gathering every piece of evidence I had. The trail camera footage showed construction crews working every day. My detailed logs documented times, dates, and activities. I had the cease and desist letter Marcus sent. I had emails and certified letters warning the HOA that they were trespassing. I took everything to the Buncombe County Sheriff's Office and asked to file a criminal complaint. The deputy who took my statement was initially skeptical, thinking this was just another HOA dispute. But as I laid out the evidence, showed the judge's ruling, and demonstrated the deliberate nature of the trespass, his attitude changed. So they just built this whole building on your land after you told them not to, multiple times. I have it all documented. And the judge confirmed it is your land. Yes, here is the court order. The deputy shook his head. Okay. I am going to pass this up to the detective division. This might actually qualify as criminal trespass and property damage. 2 days later, I got a call from Detective Sarah Kowalski. She wanted to come out to the property and see the situation firsthand. I agreed immediately. Detective Kowalski was in her early 40s, with sharp eyes and an attitude that suggested she did not suffer fools. She walked the property line with me, examined the storage facility, and reviewed all my documentation. She took photos, made notes, and asked detailed questions about the timeline of events. This is one of the more blatant cases I have seen, she said as we stood in front of the completed storage facility. Usually, these HOA things are civil disputes about fees or regulations, but this is actual criminal trespass and property damage. So you will pursue charges. I am going to recommend to the district attorney that we file charges, yes. Based on what you have shown me, there is clear evidence that multiple parties knowingly trespassed on your property, caused property damage by removing trees, and constructed an unauthorized structure. The fact that they continued after receiving a cease and desist letter and during pending litigation makes it worse. What kind of charges are we talking about? Likely criminal trespass, property damage, and possibly conspiracy if we can show that multiple HOA board members coordinated this. The DA will make the final call, but I think you have a solid case. 3 weeks after my meeting with Detective Kowalski, I received notice that the district attorney's office was filing criminal charges against Patricia Hendricks, 2 other HOA board members, and the construction foreman. The charges included criminal trespass, willful property damage, and conspiracy to commit trespass. The neighborhood exploded with gossip. Most people had no idea what had been going on. They just knew that the HOA had built a storage facility, and suddenly their president was facing criminal charges. My mailbox was full of letters from neighbors, some supporting me, others accusing me of overreacting. Patricia, meanwhile, was defiant. She sent an email to all HOA members claiming that I was persecuting her for doing her job, that the charges were baseless, and that the HOA would fight this to the end. She set up a legal defense fund and asked all members to contribute. The preliminary hearing was set for August. In the meantime, the civil case was also moving forward. The HOA's 30-day deadline to respond to the show cause order had passed, and they filed a motion arguing that they should be compensated for the construction costs and asking for the right to purchase the strip of land where they had built. Marcus filed a counter-motion seeking damages for the destroyed woodland, loss of use of the property, legal fees, and demanding the immediate removal of the structure. We were asking for $200,000 in damages plus attorney fees. Are you sure you want to push this hard? Marcus asked me during one of our strategy sessions. They might be willing to settle if we give them an out. I do not want to settle. They need to face consequences for what they did. If I let them buy their way out of this, what message does that send? That you can trespass, destroy someone's property, build whatever you want, and then just pay a fine. No, I want the structure removed, I want my land restored, and I want them to pay for all of it. Okay, then we push forward. The criminal hearing came first. I sat in the courtroom as the prosecutor. A sharp young woman named Jennifer Walsh laid out the case. She presented the property documents, the cease and desist letter, the timeline of construction, and the trail camera footage showing crews working on my land day after day. Patricia's attorney tried to argue that this was a civil matter, not a criminal one, and that there was a good faith dispute about the property boundaries. But Jennifer shut that down quickly. Your Honor, this was not a good faith dispute. The defendant was presented with clear evidence that the property belonged to Mr. Garrison. She was sent a cease and desist letter from his attorney. She continued construction anyway. That is not a dispute. That is willful trespass. Patricia took the stand to defend herself, and it did not go well. She was combative, defensive, and refused to acknowledge any wrongdoing. She insisted that the HOA had every right to develop what she called common area land, even when confronted with the survey documents proving otherwise. Miss Hendricks, the judge said, his patience clearly wearing thin, did you review the county survey records before proceeding with construction? I relied on the documentation provided to me by the HOA's previous board. Did you verify that documentation? I had no reason to doubt it. Even after Mr. Garrison provided you with contradictory evidence, I believed our records were correct. And when his attorney sent a cease and desist letter with additional proof, Patricia hesitated. I consulted with our attorney and we decided to proceed. Based on what legal theory? She had no good answer for that. Her attorney tried to step in, but the damage was done. The judge bound the case over for trial, meaning there was sufficient evidence to proceed with criminal charges. The civil trial followed 2 months later. This time, we were in front of Judge Morrison again, and she remembered the case well. The HOA brought in their own surveyor, who tried to argue that there was ambiguity in the property descriptions. Marcus tore him apart on cross-examination, showing that the surveyor had never actually been to the property and was basing his opinions solely on the fabricated documents Patricia had provided. We brought in the county surveyor, who testified that there was absolutely no ambiguity. The property lines were clear, well established, and had been consistent across multiple surveys spanning 15 years. He also testified that the document Patricia claimed was from 2008 was clearly not a legitimate survey. The trial lasted 3 days. At the end, Judge Morrison ruled entirely in my favor. The HOA was ordered to remove the storage facility within 60 days, restore the land to its original condition, including replanting trees, pay me $175,000 in damages, and cover all my legal fees, which totaled another $40,000. Furthermore, Judge Morrison said, I am imposing sanctions on the HOA and Ms. Hendricks personally for bringing frivolous claims and for engaging in conduct that wasted the court's time. Ms. Hendricks will personally pay an additional $10,000 in sanctions. Patricia's face went white. Her attorney tried to argue, but Judge Morrison cut him off. Mr. Pritchard, your client ignored clear evidence, trespassed on private property, destroyed Woodland, and then tried to use the legal system to justify her actions. She is fortunate I am not holding her in contempt. The ruling stands. The criminal trial took place in November. By that point, Patricia had lost the support of most of the HOA. The board had held a special election and removed her as president. Several board members had resigned. The HOA's insurance company was refusing to cover the legal costs, claiming that willful trespass was not a covered event. Patricia was facing everything alone. The trial was brutal. Jennifer Walsh presented a mountain of evidence showing that Patricia had knowingly, deliberately, and repeatedly trespassed on my property. The trail camera footage was particularly damaging, showing Patricia herself on the property multiple times, directing construction, inspecting work, all after she had been told to stay off. The jury deliberated for less than 4 hours. They found Patricia guilty on all counts: criminal trespass, willful property damage, and conspiracy. The 2 other board members who had voted to approve the construction were also found guilty. The construction foreman was acquitted, as the jury found he was just following orders and had no way to know who actually owned the land. Sentencing came 2 weeks later. Patricia received 2 years of probation, 300 hours of community service, and was ordered to pay restitution of $50,000 directly to me, separate from the civil judgment. The other 2 board members received similar sentences. But the real punishment for Patricia was the destruction of her reputation. The local news had covered the story extensively. Everyone in Asheville knew her as the HOA president who had illegally built on someone's property and ended up with a criminal record. She resigned from the HOA entirely and, from what I heard, put her house up for sale within a month of sentencing. The removal of the storage facility happened in January. I watched as a demolition crew tore down the building that had caused so much trouble. It took them 3 days to completely remove it, haul away all the debris, and dig up the foundation. Then a landscaping company came in and spent 2 weeks restoring the area. They brought in mature trees to replace the ones that had been cut down, replanted understory vegetation, and restored the natural contours of the land. By the time they were finished, you could barely tell anything had been built there. My woodland was back, perhaps not exactly as it had been, but close enough. The trees would need time to grow, but in a few years, it would be like none of this had ever happened. The new HOA board reached out to me in February. They wanted to apologize for everything that had happened, and to assure me that nothing like it would ever occur again. They had implemented new policies requiring verification of any property claims before taking action, mandatory legal review of major decisions, and term limits for board members to prevent anyone from accumulating too much power. I appreciated the gesture, but I remained wary. I had learned that HOAs, even with the best intentions, could become weapons in the wrong hands. Patricia had been a cautionary tale, but she was not unique. There were hundreds of Patricias out there, micromanaging neighborhoods, obsessing over property lines, convinced that they knew better than everyone else. The money from the judgments came in slowly. The HOA had to assess every homeowner a special fee to cover the civil judgment, which made me very unpopular with some neighbors. But most people understood that Patricia had brought this on herself, and by extension, on the HOA. The HOA's insurance eventually covered a portion of it after a lengthy dispute, but the homeowners still ended up paying about $80,000 collectively. Patricia's personal payments came through a payment plan. She was making monthly installments on both the criminal restitution and the civil sanctions. I did not particularly care about the money at that point. The amount was significant, yes, but that was never what this was about. It was about standing up to someone who thought they could bully their way onto my property and do whatever they wanted. In March, I got a handwritten letter from Patricia. It was not an apology exactly, but it was close. She wrote that she had been trying to do what she thought was best for the neighborhood, that she had genuinely believed the HOA had the right to develop that land, and that she had made mistakes. She did not explicitly apologize, but there was a tone of regret in the letter that suggested she understood, at least partially, how badly she had messed up. I never responded to the letter. There was nothing to say. She had made her choices, and she was living with the consequences. Life in Pinewood Springs slowly returned to normal. The new HOA board was much more cautious and reasonable. They focused on basic maintenance and common area upkeep, staying out of people's business unless absolutely necessary. My interactions with them were minimal and professional. I spent that spring and summer enjoying my restored woodland. I took up bird watching, identifying the species that returned as the new trees matured. I set up a hammock between two oaks and spent long afternoons reading out there. The piece that I had bought the property for in the first place was finally restored. People occasionally asked me if I regretted pushing things as far as I did. After all, I could have settled early, taken some money, maybe kept the storage facility and rented out the units. It would have been profitable and would have saved everyone a lot of time, money, and stress. But I never regretted it. Not for a moment. What Patricia did was not just a property dispute or an HOA overstepping its bounds. It was a fundamental violation of property rights. She looked at my land, decided she wanted it for her project, and simply took it. She fabricated documents, ignored legal warnings, and plowed ahead because she thought she could get away with it. If I had let her get away with it, if I had settled and allowed the storage facility to remain, I would have been validating that behavior. I would have been telling Patricia and every other petty tyrant in every HOA across the country that you can just take what you want, and the worst that will happen is you will have to pay for it after the fact. That was not a precedent I was willing to set. The legal system worked the way it was supposed to work. I proved my ownership, documented the trespass, and held the trespassers accountable. It took time, it cost money, and it was stressful, but it was worth it. By the following autumn, 18 months after this whole mess started, I was sitting on my back deck on a cool October evening, watching the sunset through my woodland. The trees were showing their fall colors, brilliant reds and oranges and yellows. A deer wandered through, stopping to look at me before continuing on its way. The air was crisp and clean, and everything was quiet except for the rustle of leaves and the distant call of a crow. This was what I had bought. This was what I had fought for, and I had won. My phone buzzed with a text from Marcus. We had become good friends through this whole ordeal, bonding over the absurdity of the situation and the satisfaction of winning. His text was simple. Saw Patricia listed her house, selling for way under market. Guess she really is leaving. I texted back, good riddance. And that was that. Patricia Hendricks, the HOA president who thought she could build on my woodland, was gone. The storage facility she had been so determined to construct had been demolished and hauled away. The land was restored. Justice, both civil and criminal, had been served. I set my phone down and picked up my beer, raising it in a silent toast to the woodland, to property rights, to standing your ground when you know you are right. The sun finished setting, painting the sky in shades of purple and pink. The first stars appeared overhead. Somewhere in the distance, an owl began to hoot, calling out into the gathering darkness. I smiled, finished my beer, and went inside. Tomorrow was another day, and for the first time in a long time, I could face it knowing that my property was truly mine, that the boundaries were clear and respected, and that anyone who thought otherwise had learned a very expensive lesson. The Pinewood Springs development continued on around me. Houses full of families and retirees, people living their lives, mostly ignoring the HOA and being ignored in return. That was how it should be. That was how it would be, at least for the foreseeable future. And if another Patricia ever came along, if another HOA president decided they knew better than property deeds and surveys and the law itself, well, they would have my case to look at. They would have the story of the HOA that built a storage facility on private property and lost everything. It was a good story. It was a true story. And it was my story. I slept well that night, better than I had in months, secure in the knowledge that my home was my own, my land was my own, and nobody could take that away from me. The final payment from Patricia arrived the following spring. It was the last installment on her restitution, and with it, the financial aspect of this entire mess was finally closed. The check was for $800, which brought her total payments to the $50,000 she owed. I deposited it without ceremony. Marcus called me a few days later with news that Patricia had officially moved out of state. She had taken a job in Florida, leaving North Carolina and all the baggage that came with it behind. Her house had sold to a young couple with 2 kids who seemed nice enough. I met them at a neighborhood gathering, and they had no idea about the history of the previous HOA president. I did not enlighten them. They would learn about HOA politics in their own time. The new HOA president was a retired engineer named Tom, who ran the board like a well-oiled machine. Meetings were efficient, decisions were data-driven, and there was no drama. It was boring in the best possible way. I paid my dues on time, kept my property maintained, and never heard a word of complaint. Life went on. But the story did not stay contained to just Pinewood Springs. Somehow, one of the local news stories made it onto a popular online forum, and from there it spread. I started getting messages from people all over the country, thanking me for standing up to an abusive HOA, sharing their own horror stories, asking for advice on how to handle similar situations. I responded when I could, offering what wisdom I had gained from my experience. The main lesson was always the same: document everything, know your rights, and do not back down when you know you are right. Most people gave up too easily when facing HOA pressure, assuming that the HOA must have the legal authority to do whatever they claimed. But HOAs are just organizations run by neighbors. They have limited powers, and those powers do not include taking your property or violating your rights. A few lawyers contacted me, asking if they could use my case as an example in seminars and publications about property law and HOA disputes. I agreed, hoping that it might help others facing similar situations. One attorney told me that my case had already been cited in 2 other lawsuits involving HOA overreach. In both instances, homeowners had used my case to demonstrate that criminal charges were possible for HOA members who willfully violated property rights. One of those cases settled quickly once the HOA realized they could face criminal liability. The other was still ongoing, but the homeowner's attorney was confident. I found satisfaction in knowing that my fight had helped others, even if that was never my intention. I had just wanted to protect my property and hold trespassers accountable. The broader impact was a bonus. As the years passed, the woodland continued to mature. The trees that had been planted grew taller and stronger. The wildlife returned in full force. I saw foxes, raccoons, opossums, countless birds, and even a black bear once passing through in the early morning hours. I never forgot what had happened, but I stopped being angry about it. Patricia had paid her price, both legally and personally. The HOA had learned its lesson. My property was restored. There was nothing left to be angry about. On a warm evening in June, 5 years after the whole mess started, I hosted a small gathering on my back deck. Marcus was there with his wife, along with a few neighbors I had become friendly with over the years, and my girlfriend Amanda, whom I had started dating a couple of years after the legal battles ended. We grilled steaks, drank wine, and watched the sunset over the woodland. Someone brought up the storage facility story, as people inevitably did when they learned about it, and we all laughed about the absurdity of it. It had become a good story, the kind you tell at parties, rather than a source of stress and anger. Do you ever wonder what would have happened if you had just let them keep it? Amanda asked as we sat together later that evening, the others having gone home. Sometimes, I admitted, but I know I made the right choice. It was not about the money or even the land, really. It was about the principle. You cannot let people just take what is yours because they think they can get away with it. I am glad you did not, she said, leaning against my shoulder. This place is perfect. I cannot imagine it with a storage facility in the middle of the woods. Neither can I. We sat in comfortable silence, listening to the night sounds of the woodland. An owl hooted in the distance. Crickets chirped. The breeze rustled through the leaves with a sound like soft rain. This was home. This was peace. This was everything I had worked for and fought for. And nobody could ever take it away.